All right, good afternoon, everyone. I'm Judge Jackie Powell, and we're back for the afternoon. We are going to start with the first appearance docket first, and then we'll move to the hearing docket. For those of you who are here for first appearance, today I am going to tell you whether I find probable cause to detain you, and then we can talk about release conditions. Today is not your trial date, so I would advise you not to speak on the record about your case. And I'm sure that your attorneys will tell you not to talk about your case on the record because everything in this courtroom is being recorded and can be used against you at a later time. For those of you who are represented by the attorneys from the Public Defender's Office, Attorney Corey Hill is over there at the main jail. He'll speak with you, and I do have an attorney, Mr. Adam Goldberg from the Public Defender's Office, in the courtroom with me. I also have in the courtroom the state attorney, Mr. Eric Linder. So when you come up, we will address each of you individually, and then we'll go from there. So we'll start with Ricky Padilla.
Judge, he's up in North Broward.
Thank you. Broward. All right, Mr. Padilla, you're before the court this afternoon for count 1 is bribery of a public servant, and count 2 is violation of injunction protection for domestic violence. I do find probable cause as to both those counts, and I will hear from your attorney and the attorneys in regards to setting a bond.
Your Honor, on count 2, I'm going to be requesting a $25,000 bond, pretrial release of the GPS monitor level 1 and no victim contact. And I know that's a high bond and strict conditions, but Your Honor, I believe this bond and conditions are, at this point in time, the only things that will prevent or keep Mr. Padilla from continuing to go to this person's home and violating this restraining order. Your Honor, I provided both the court and defense counsel a copy of the victim's petition. And, Your Honor, reading the petition, it would appear to me that she is in great fear, Mr. Padilla. She has sought protection from law enforcement, where she was told really her only course of action was to seek an injunction, which she did, as a law-abiding citizen should. He was ordered, and he received notice, and was ordered not to have contact with this person, not to go to the home. I've also provided the court with the probable cause affidavit from his arrest this past Friday. He broke into the home, committed a grand theft, and violated the injunction. He went in front of the judge this weekend. He got a $1,000 bond on each count. He bonded out and was released on Saturday. And now, here we are, a few days later, and he's back before the court for, again, going to this person's home, violating the court's order and the injunction, violating Judge Clora's order to have no contact. I just don't see any other means at this point to ensure that he will honor the court's orders.
Okay.
Judge, good afternoon. I spoke with Mr. Padilla. He's advised me that he's a Fort Lauderdale resident. He's lived here for the last 10 years. He lives with his mom, his dad, his sister, and his 2 nieces in Southwest Fort Lauderdale, and he did provide me the address. He has been working for an Italian restaurant. He doesn't think that there's much money, though, that he will have, and he's unsure if he'll have that job following his arrest here. He's advised me that the most bond he thinks he can afford is $500, so that would really be $5,000 through a bondsman. So, Judge, I would ask that the total bond set be $5,000 between the 2 counts. As to count, I think count 2 is the more serious of the 2 counts. As to count 1, it sounds like it's an offhand remark that he made to a police officer in the back of the police car where he said, "Hey, I'll give you $100 if you let me go," allegedly, Judge. I'd ask that the bond on that one be lowered from $3,500. And again, between the 2, I'll leave it to the court's discretion, but I'd ask that the sum total be $5,000. Obviously, if the court wants to also attach pretrial or other conditions, that's the court's prerogative. Thank you, Judge.
Okay. Based on the allegations that have been presented to me this afternoon, taking into consideration that Mr. Padilla was here this weekend before another judge who did give him a bond. And after bonding out, he failed to follow that judge's orders. And here we are on Tuesday before the court for similar allegations. I do find probable cause as to both counts. I don't know if it was an offhand comment. I can only go by what's been presented to me today. So I am going to leave the bond in place for count 1 at $3,500. And on count 2, I am going to impose a $20,000 bond. If Mr. Padilla poses bond, he will be on GPS monitor. And though it was said before in the petition for the injunction on Saturday before another judge, I'm saying it again, no victim contact. That means no phone calls, no text messages, no appearing at the home, no asking a third party to speak on your behalf. Good luck, sir. Moreno Echeverria.
Bonded.
Okay. Echeverria Moreno. Deanne Forges.
Bonded.
Okay. Joshua Joseph. Mr. Joseph, you're before the court this afternoon for one count of a traffic capias on a driving while license suspended matter. And I do find probable cause. What does Mr. Joseph wish to do? Is he represented by?
He declined the PD's office, Your Honor.
Okay, thank you.
I can advise the court, Your Honor, if Mr. Joseph wishes to resolve the matter, the offer from the state is a withholding court cost.
All right. Mr. Joseph, I'm noting that you surrendered yourself on this KPS, and it is for a traffic matter, driving while license suspended. The state's offer to you, if you wish to resolve your case, is a withhold adjudication and court costs. I'm not telling you that you have to resolve your case. I'm just letting you know what the state's offer is. So what do you wish to do, sir?
Okay.
What does okay mean?
Withhold.
Okay. All right. Then, Mr. Joseph, please raise your right hand. You swear or affirm to tell the truth?
I do.
Okay, you can put your hand down, sir. Mr. Joseph, do you understand everything that's going on here today?
Correct.
Are you under the influence of drugs or alcohol?
I am not.
And have you ever been treated for a mental or emotional illness?
I have not.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
I am.
And you understand that you have a right to go to trial, but by taking a plea today, you are giving up that right.
Correct.
What plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your no contest plea, sir. Find that it's freely and voluntarily given. Your sentence will be a withhold adjudication and court costs. Good luck, sir.
Okay.
Otero Portillo.
Bonded.
Thank you. Renee Jimenez.
Bonded.
Okay. Silas Whitehead.
Judge, I've been informed he has a private attorney. I believe it's George Odom,
Okay,
but I just got word, so I haven't spoken to Mr. Odom.
all right. Sir, do you know when Mr. Odom was retained?
In January.
But these are new charges. So, when you hired him in January, you hired him for something else?
Yeah.
Do you know Mr. Odom's number?
954
Yes?
263
Uh-huh.
7657.
Okay. I'm sorry, what were you saying? Oh, he's been in custody since January? Okay. So what's the bond status on the other charges, on the other counts? Do you know?
Yeah.
This is Mr. Whitehead, Your Honor?
Yes. He's being held no bond?
Yeah. It looks like there's a capias, there's a court order, which I suspect was a bond revocation, $5,000 bond on a burglary dwelling.
All right, so these are additional charges. I'll let you know that these are additional charges. Count 9 is for burglary. Count 10 is for grand theft. Let me try and see if I can get Mr. Odom on the phone just so that we can have him notified. All right, Mr. Whitehead, I'm gonna ask you to take a seat for a minute. The phone's ringing and no one's answering at the number you gave me. So we're just gonna verify and we'll make a phone call, okay? Just have a seat for a moment. Wayne Chin.
Judge, I was also just informed that he declined the public defender's office as he's represented by Mike Salazar.
Mr. Chin.
Yeah, Mr. Chin, yeah. But again, I just got that call, so I haven't spoken to Mr. Salazar.
All right. What's Mr. Salazar's number? Is that who you're calling?
I'll see if I can find it, Judge.
Okay. No. Okay.
It's okay. Just gotta look at something for him. Okay, Judge.
Yes.
Mr. Salazar. 954. 467.
Okay.
Janice, I'm sorry, but to give you the heads up, there's 2 misdemeanor motions to release.
Office, how can I help you?
Good afternoon. This is Judge Jackie Powell, and I'm calling from Open Court and First Appearance Court.
Okay.
I'm looking for Attorney Mike Salazar.
Okay, and this is regarding?
This is regarding Wayne Chin, who is before the court this afternoon, and he's advised us that Mr. Salazar is his attorney.
court notice that we received.
This is first appearance.
Okay, let me see.
This magistrate.
What is the last name?
Chin, Chin.
Wayne.
Yes.
1 second, okay?
Okay. Mr. Chin, do you know when Mr. Salazar was hired? This
is Attorney Michael Salazar.
Mr. Salazar, this is Judge Jackie Powell. I'm calling from Magistrate Court. I have Wayne Chin before the court this afternoon who tells me that you are his attorney.
No, but I can be. I know Mr. Chin. If Your Honor, if you could tell me what he's being charged with.
Are you sure?
Mike, it's Eric Linder, the State Attorney's Office.
How are you?
Good, how you doing?
Good, thanks.
Let me put it this way. The charges are of a sensitive nature. The public defender normally would ask to have these charges waived.
I understand. I haven't spoken to Mr. Chin. He is my prior client. I can go ahead and come on. Yes, I can represent him. And so yes, so the answer would be yes, Your Honor.
All right. Well, Mr. Chin is before the court for 6 counts, and I do find probable cause on these charges, and I will hear from the state as to the bond.
Thank you, Your Honor. Your Honor, on the 3 counts that are capital offenses and the counts 4 through 6, which are punishable by life offenses, the state would be seeking a finding of proof evident or presumption great for first appearance purposes only, and a no bond hold on these 6 counts. Your Honor, I'd be relying upon the probable cause affidavit prepared by Detective Michael Silver of the Pembroke Pines Police Department. I believe the court is familiar with the allegations in the report. I won't go into details. I would note that the report contains substantial details from the alleged victim, and there are also admissions made by Mr. Chin contained in the report as well. And obviously, in addition to whatever the court sets as far as bond, the state would be asking for an order of no victim contact with SM.
Okay. Mr. Salazar?
Your Honor, not knowing the true nature of the charges, but I could surmise, I would ask you to set a reasonable bond with a monitor. He does have significant ties to the community in Broward County. I don't believe he has any significant priors, and I believe he's employed, or he was employed prior to this. Based on that, I believe that a reasonable bond with a monitor would safeguard the community and assure his appearance in future court proceedings.
All right. These allegations are pretty serious, and so I have to take that into consideration at this time, despite his limited interaction with the law. And so at this time, on counts 1 through 3, I find probable cause on all counts. Counts 1 through 3, I am going to impose a bond of $25,000 on each count. Then on counts 4 through 6, I am going to make a preliminary finding of proof evident presumption great with without prejudice, and Mr. Chin will be held no bond on those counts.
Your Honor,
Yes.
is the court not finding proof evident or presumption great on 1 through 3?
Well, that's very hesitant and all of on these charges.
Well, Your Honor, I mean, I
No,
wouldn't.
no, don't. No, it's not. It's not about the argument that you're making. Just. All right, let's do this. I am making finding of probable cause. On all counts, I'm making a further finding of proof evident presumption great. Guess that's what I did not say before. On, I'm going to exercise my right to set a bond, and then on counts, did you make an argument as to bond?
Well, Your Honor, are you setting bond on all counts, Your Honor?
That was not my intention.
Okay, that's why I'm inquiring. If, and I'm trying to avoid a back and forth.
All right.
But just so I know what counts, okay.
All right. Making a finding of proof evident presumption great on all counts without prejudice. Mr. Chin can have his author hearing before his division judge, and I will leave all the counts at no bond hold at this time.
Thank you, Judge.
All
And,
right.
Your Honor, no victim contact with
And,
SM?
No. Hold on just a minute. I'm trying to write it in. And no victim contact with the alleged victim with the, what are the initials?
SM,
Okay.
thank you.
All right. All right, Mr. Salazar, thank you.
Thank you, Judge.
All right,
Have a good day.
Mr.
Thank you.
Chin,
Bye-bye.
good luck. All right. Tyron Neal. Oh, I'm sorry. We have our Spanish interpreter. Who needs a Spanish interpreter?
Judge, one of the jails.
Conti, Your Honor.
All right.
He's on the
What's his name?
ROR list. Your name? Carlos Pineda.
This is one of the,
Yeah.
this is one of the cases I was talking about.
What's the defendant's name? Or
Carlos
the case
Pineda,
number?
I wrote it down for our clerk.
I
Your Honor, the
don't.
Public Defender's Office set this for a motion to release on the misdemeanor docket.
Okay.
For some reason, it didn't get put on the docket.
Does
Carlos
he,
Pineda.
did he get all that, Mr. Pineda?
Well, I have the docket. All right. Okay. Mr. Pineda is brought before the court today
Señor Pineda ha sido traído ante el tribunal en el día de hoy
for a 30-day motion.
por una moción de 30 días.
Is that correct?
¿Estamos en lo cierto?
Yes, it is.
Sí lo es. Sí es así.
And when was Mr. Pineda arrested?
¿Cuándo fue que arrestaron al señor Pineda?
One moment, Judge.
Un momento, juez.
February 22nd.
El 22 de febrero.
Okay. So Mr. Pineda was arrested on 2/22 of this year, 19.
Muy bien. Fue arrestado el 2/22 de este año. 19.
The charges are a violation of injunction.
El cargo o la acusación es que quebrantó el interdicto
And it looks like count 2 is violation of a pretrial.
y aparentemente el segundo cargo es que quebrantó los términos de probatoria.
Your Honor, he was originally arrested on one count of violation of an injunction.
Inicialmente fue arrestado por violar un cargo del interdicto.
When the state filed the information, we added a charge of violation of a pretrial release condition, that being the no contact order.
Y cuando el Estado se enteró, pues añadimos la acusación de quebrantar una orden con antelación al juicio de que no tuviera contacto con la víctima.
At the time of this arrest, there was another pending case where there was a no contact order issued.
Al momento de su arresto había otra orden de no tener contacto en el que había una orden de arresto pendiente.
Not really relevant to this charge. I just wanted to advise you that's where the no contact order came from.
No es pertinente a este caso, pero de ahí nace o surge la orden que en este caso estamos atendiendo de no tener contacto.
All right, so what is the status of this case?
Pues, ¿cuál es el estado actual de este caso?
And just for the record, the case number is 19-2073 MM10A.
Yes, and
Para fines de las actas, este caso, el número del caso es el 192073 MN10A.
Your Honor, the information was e-filed with the clerk's office this afternoon.
Okay.
Su señoría, la información se presentó por medio o formato electrónico a la secretaría del tribunal.
All right, so Mr. Pineda,
Muy bien, pues señor Pineda,
the state has informed me
la fiscalía me informa
that the charges have been filed,
que los cargos han sido presentados
and so there is no action for me to take today.
y por lo tanto no puedo tomar acción alguna en el día de hoy.
Okay, you'll be before your division judge to handle these cases further.
Usted será referido ante el juez de la división que le corresponde para procesamiento ulterior.
Good luck, sir.
Buena suerte, caballero.
Okay, is there anyone else who needs a Spanish interpreter? Anyone?
¿Alguien más
Not from the main
que...
jail, no, Judge.
Okay, thank you very much.
Thank you, Judge.
All
Thank you
right.
all.
All right, let's go back to our first appearance docket. Tyrone Neal. Mr. Neal, you're before the court. There's count one, municipal ordinance violation. And then counts 2 through 7 are felony violation of probation. Those are all no bond holds. It looks like you'll be going to court tomorrow before your division judge at 8:30. I do find probable cause, and the bond on count one is $100. Good luck. Sair El Masri.
Judge, at this time, the individual declined the services of the public defender. They do believe he's hiring private counsel.
All right.
But if the court would allow me to act as a friend of the court.
Thank you.
Judge, his bond is set at $1,000, and speaking with him while he wasn't out, it's simply because of communication. He provided me his wife's phone number and indicated I will call her upon my leave here today, and he knows his wife will be able to post that $100 bond on count 2.
All right. State.
I wasn't asking for any kind of modification.
All right. All right, Mr. El Masri, just you are before the court for count 1, possession of cannabis 20 grams or less. Count 2 is possession of a controlled substance without prescription. Count 3 is operating without a valid license. 4 and 5 are traffic infractions that are not for magistrate. I do find probable cause, and your bond on count 2, as you are already aware, is $1,000. Good luck, sir.
Thank you. I promise I'll call her as soon as I get out of here.
Daniel McKenzie. Mr. McKenzie, you're before the court. Count 1, driving a license suspended. Count 2 is felony violation of probation. That's a no bond hold. Count 3 is a writ of attachment with a civil purge in the amount of $550. That's not for magistrate. I do find probable cause, and your bond on count 1 is $100. And
Judge, can I just put this case on recall for just a moment, please?
why? What are we doing? The violation of probation is out of Alachua County. He's talking to them? What about count 1? Oh. Okay.
Sorry, Judge, we just, what's that?
Strategy sometimes.
Yeah.
Judge,
Yes.
go ahead, Mr. Goldberg, I'm sorry.
No.
Judge, in regards to Mr. McKenzie, he is aware it's out of, up by Gainesville in Ocala, the probation violation. As far as count 1 is concerned, as you're aware, BSO is not going to transport him to deal with this until his matter is resolved or he's released from custody. Would the court consider a ROR on count 1, so this way he can get up there and deal with his responsibilities up north?
Okay. I'll grant the ROR on count 1. Richard Concepcion?
Thank you, Judge.
You're welcome. Mr. Concepcion, you're before the court for 1 count of possession of MDMA, and I do find probable cause.
Thank you, Judge. Mr. Concepcion is 24 years of age. He does reside with his stepfather for the past 3.5 years. He does work in construction. It's steady work. So I asked him if he was able to afford the monetary bond, but unfortunately he's not. He does suffer from medical injuries. He does have some support on his waist area. He's got disc problems as well as scoliosis, and his money's been going to pay for those bills. That's why he's unable to post this financial bond. Would the court consider an ROR in this matter?
Does Mr. Concepcion have other drug charges?
No, I don't see any prior drug charges.
And nothing prior?
It looks like he may have a pending traffic matter out of West Satellite. Nothing very, it's not like a DUI or anything.
Okay. All right, I'll grant the ROR.
Thank you, Judge.
Lester Brown?
Approaching.
All right, Mr. Brown, you're before the court for 1 count of grand theft. I do find probable cause.
Sure.
Anyone wish to be heard as to Mr. Brown?
Yes, Judge, thank you. Mr. Brown wanted me to inform the court that no items were actually removed from Walmart. All matters were returned. According to Mr. Brown, he indicated the threshold of the probable cause affidavit is just over $300. If that's the case,
$367.13.
well, I was going to argue tax, but that would be too much of a tax to bring it below to 300. Unfortunately, at this time, he is homeless. He's 50 years of age. He's not working at all as well. He's unable to financially post that bond. Would the court consider ROR because pretrial obviously is not an option due to him having a lack of address?
Your Honor, the state would be opposing an ROR. Mr. Brown's most recent prior was a 2012 grand theft auto under the name Lester Newkirk, where he was sentenced to 5-year state prison. I'm showing that Mr. Brown is a registered sex offender. 1995, he was convicted of 4 counts of sexual battery using a weapon or force, 2 counts of aggravated battery on a pregnant victim, 1 count of aggravated assault. After a violation of probation, he was sentenced to 17.5 years state prison.
All right, I'm going to deny your request for ROR. Mr. Brown's bond is $1,000.
Judge, if possible, Mr. Brown would like to speak to the court.
Okay?
Ma'am, with all due respect, what the state is making an argument of is a case involving my then wife, who came before the court, recanted in front of Judge Spicer as well, in front of Judge Joyce A. Julian. This is one case; it's not 5 cases on the SPAC. I haven't been in any trouble. I haven't committed any crime of such nature because that wasn't the case. If that was the case, he would have had some form of repeat. I haven't committed any violent crime in over 30 years. I've only been home for about a year now, and I'm struggling to get into some form of reintegration program. I've been sleeping behind the Walmart, and
Judge, I was trying to inquire about whether maybe, due to maybe a substance abuse problem, we could place him custody to custody in a facility, but we are worried that the 1995 offense is going to prevent him from entering any of these type of programs.
It won't take me because
Right. Well, I think that then that's something he has to work out with his attorneys.
I don't want to send the attorney.
I can't put him on pretrial release if he doesn't have an address, and I'm not
I can give
denying.
an address outside the county.
So,
Up there?
Yes.
Judge, he's indicating he has an address outside of the county. Which county?
It'll be up in Jupiter.
Jupiter County.
it's not gonna work.
I don't know that.
All right, the bond is $1,000. If you guys figure out something else, you can come back before the court. Ruben Aboy. Mr. Okay.
Yeah. But, yeah.
Oh, on Mr. Whitehead. What was that? What was the name of the attorney again? Mr. Goldberg? Do you
Mr.
still have
Whitehead,
that?
I think it was Mr. Odom. Yeah, Mr. Odom.
Do you have access to his
I think I have
his phone number?
His number, yeah.
Judge.
Yes.
Come on up, sir. Give me a second, sir.
Yeah, no, I'm just trying to get Mr. Odom's number because
Thank you.
I'm trying to verify that the number he gave us was correct.
Okay, thank you.
Devin? How did I know?
Huh?
263-7657.
Law office.
Good afternoon. This is Judge Jackie Powell, and I'm calling from Magistrate Court. I'm looking for Mr. Odom.
Good afternoon, Judge. You got him. How you doing?
I am well. Mr. Odom, I have Silas Whitehead before the court this afternoon, and he tells me that he's represented by you.
Yes, Judge. Just so the record's clear, Judge Bober appointed me to the three cases that was in Judge Bober's division. PD's office was conflicted off, and OCCRC was also conflicted off. So my plans, I'm currently not on the case, but my plans was to file a motion. Mr. Whitehead called me today and told me he was going to be in first appearance, was to file a motion in front of Judge Bober and ask to just go ahead and be appointed to the new case, I guess, that they're charging cases that they're charging him with now, being that I know the PDs and OCCRC will not be able to represent him just based on the previous conflicts. I don't know if the court wants to be presumptive and avoid that procedural loophole, or I guess I should say delay.
What's the case number? Because what these are additional charges. So,
right, they're totally different cases.
Oh, it's not the case that you...
This is not
right, because the three cases that I was placed on, the PD's office was conflicted off due to co-defendant issues, and then OCCRC was placed on all three cases. However, I was appointed by Judge Bober on those three cases because the client was seeking to vacate his plea, which by nature, he was saying that the attorney for OCCRC involuntarily coerced him into the plea. So I know for a fact now that OCCRC is not going to be able to be on that case now.
All right, then I'll appoint you on this case as well.
Okay. And I would just ask for JAC purposes, it has to be clear on the order that the PD's office was in conflict and thus could not be appointed, and OCCRC is conflicted and thus cannot be appointed.
Do you want to submit the order and I'll sign it?
Absolutely. If I'm out of the office today, but I don't know if you want me to submit it to you via your JA or however you want me to do it, I can do it. It just needs to be clear that the PD's office, even if it's on if Mr. Goldberg don't mind, even if it's in short order, PD's office conflicted, OCCRC conflicted.
I see Mr. Goldberg is reaching for an order. Mr. Goldberg, are you writing an order?
No problem at all.
So Mr. Goldberg will facilitate that order for you, Mr. Odom.
I appreciate his voluntariness to assist.
All right. So the two charges, the two counts that Mr. Whitehead has now is burglary of an unoccupied structure unarmed, and then count 10 is grand theft. Okay.
So I'm not going to preserve any PC argument at this time. We do have a sentencing that's coming down the pipeline, as long as a motion, a youthful offender motion, but I guess I'll address it now with these new charges in front of Judge Bober. So I'm not. I'll just leave. If there's a standard bond, I'm not going to ask for any type of release at this point because he's already been in for a number of months.
Okay.
Mr. Whitehead has a $5,000 bond on a burglary dwelling, so because it's a structure, I was going to request a $3,500 bond.
Okay. All right, so on count 9, then we'll do 3,500, and count 10's got $1,000.
That's fine with us, Judge.
all right.
And I would advise Mr. Whitehead just sit still, not attempt to bond out on that, because as he probably clear, he knows. So,
Okay.
But I have no issue with the bond.
All right. All right, thank you.
All right, thank you, Judge.
Have a good afternoon.
You as well. Thank you, Mr. Goldberg.
All right.
Your Honor, we had the perfection that was supposed to be on the docket this morning.
Yes, is he here?
I hope. Dalvin present. I'll check to see which facility he's supposed to be at.
All right, so Dalvin president, do we have him this afternoon?
He's supposed to be at the main jail. I don't know if they brought him back from court.
He's not present. He's not on our docket.
Well, yeah.
Yes, he was supposed to be on this morning for perfection from yesterday. And then he wasn't there this morning, and we asked for him to be there this afternoon. There's a 24-hour PC perfection.
Corey, if I give you guys the arrest number, can they check to see if he's actually physically in the main jail at this point?
ESO's already ahead of us. They're on top of it, checking now. If you just want to place this on recall.
That's fine.
Thank you.
All right. So then we can go to the hearing docket. We'll start with the all right, let's start with the shorter one first. Madam Clerk, what is this, another person that's added on?
It's a second.
Mr. Linder, are you working overtime today?
Yeah. It's a the public defender's office filed 2 motions to release on misdemeanors.
What is this name? Lucretia? What is the name? Steele?
Yeah, let me
She's in North Broward, Your Honor.
Thank you.
Well,
and Your Honor, the state has not filed an information at this point.
Okay.
So Ms. Steele is entitled to an ROR. The only thing I would ask, if you could advise her that the no contact order that the court originally placed is still in effect.
All right, Ms. Steele, do you understand what's going on?
yes, ma'am.
All right, so I will sign the order granting your release based on the fact that the state has not formally filed the charges.
What was the case number, Judge?
19-1866 MM10A. And all the prior orders, though, no contact, whatever the orders are, those are still in place. Do you understand that?
Yes, ma'am.
All right, good luck. Ricky Brown.
Conti, Your Honor.
Thank you.
Judge, I spoke with Mr. Brown. He'd like to resolve this case today if possible. It's a misdemeanor cannabis.
So Mr. Brown was arrested on March 22nd for possession of cannabis, 20 grams or less. I'm being advised by your attorney, sir, that you wish to resolve the case. Is that correct?
Yes.
State, do you have an offer for Mr. Brown?
Offers withholding court costs.
All right, Mr. Brown, the offer is withhold adjudication and court costs. Do you understand what that means?
Yes.
And is that what you want to accept?
Yeah.
Okay, please raise your right hand, sir. You swear or affirm to tell the truth?
I do.
Okay, you can put your hand down. Mr. Brown, do you understand everything that's going on here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Do you need more time to speak with your attorney?
No.
Are you under the influence of drugs or alcohol?
No.
And do you understand that you have the right to go to trial? By taking a plea today, you are giving up that right.
Correct.
And have you ever been treated for mental or emotional illness?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
All right, what plea do you wish to enter, Mr. Brown? Guilty or no contest?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given. Your sentence, sir, is a withhold adjudication and court costs. Good luck. Andrew Lingley Seiler. All right, Mr. Zeiler was arrested on March 22nd. It's for possession of drug paraphernalia.
Yes, Yes, if he wishes to resolve the case, Your Honor, his bond's currently $100. If he wishes to resolve the matter, the offer from the state's will withhold the court costs.
Judge, yes, you'd be in agreement with that and enter a plea of no contest, please?
All right, Mr. Zeiler, so you're excited over there. Please raise your right hand. Do you swear or affirm to tell the truth? Okay, turn the mic on.
My fault, sorry.
All right,
Yes, ma'am.
you can put your hand down. Mr. Zeiler, do you understand everything that's going on here today?
Yes.
And do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Have you ever been treated for mental or emotional illness?
A long time ago, yeah.
Are you taking anything today that would affect your making a decision today? And do you understand that if you're not a U.S. citizen, that by taking a plea it could subject you to immigration changes?
Yes.
What plea do you wish to enter? Guilty or no contest?
No contest.
All right, I accept your no contest plea, sir. Find that it's freely and voluntarily given. Your sentence is a withhold adjudication and court costs. Good luck, sir. All right, let's go to our felony hearing docket. Emmanuel Colson.
No response in the main jail.
No, Broward.
Okay. Mr. Colson was arrested on March 22nd. He's here for a second look at his bond status.
His bond, I believe, is $1,000. This is a not in custody case, Your Honor, so it is filed. It involved theft of $400 worth of merchandise at a Home Depot. Mr. Colson's criminal history includes 2016 grand theft, VOP, 29 months state prison as a habitual offender, 2016 theft, 2013 grand theft, 26 and a half months state prison as a habitual offender, 2013 burglary of a conveyance, same sentence, 04 burglary of a conveyance, 9 years state prison as a habitual offender, 2000 burglary conveyance, 3 years, 96 burglary of a structure, 96 months, 96 burglary of a structure, grand theft, 96 months, 96 armed burglary of a structure and 3 counts of grand theft, 96 months state prison. And see, 1, 2, 3, 4, 5, 6 additional burglary structures in 1996.
Your Honor,
Judge,
Your Honor,
Mr. Colson, I can handle it. You and I spoke.
yes, sir.
So, Judge, criminal record aside, Mr. Colson advised me that he turned himself in on this case, that he notified law enforcement as he thought that there was a not-in-custody capias out there for him. He made contact with law enforcement. They verified that, and they arrested him and brought him into the jail. Judge, he's working, trying. Can't read my own handwriting here. I'm sorry. That's it. He's working with his uncle. Since he turned himself in, Judge, he's asking if the court will consider releasing him on his own recognizance. He was the one who was made aware of the warrant, and he notified law enforcement so that way he could surrender, is what he advised me.
Well, it does say that he surrendered himself. At least that's correct. As far as the...
Your Honor, I am showing, though, that at least his last case in Broward, which was the grand theft, where he is had his probation revoked, he was sentenced to 29 months and just got released. He got picked up on failure to appear warrants in that case. I see at least 3.
Okay. All right, I am going to deny the motion for ROR. I'm leaving the bond in place at this time.
Your Honor.
Yes,
I
sir.
served I served all my time for all those charges. I even this year I even turned myself in to a drug rehab called BART, and I have been working on my recovery. And I have yes, in the past I was living like that, but now I'm working on my book. I'm trying to get my book published, and I'm trying to stay out of trouble. I was notified from BART that this warrant came up, and I'm trying to do all I can do to stay out of trouble. My people have been trying to find someone to sign for my bond, which he can't find someone because he don't want to sign because he's on life parole.
All right, Mr. Colson, talk with your attorney, and then you can work out something if we have to come back before the court. Okay?
All right. Your Honor, what about pre-trial on one of the
No, I'm not.
Those charges are old charges, Your Honor. I mean, I did my.
All right, Mr. Colson, I'm moving on. You speak with your attorney, Robert Webb.
It's a motion to release, Judge.
Yes, Robert Webb.
Locate him first.
Conti, Your Honor, Robert Webb.
Oh, I'm sorry.
All right. Okay, Mr. Webb.
1 second, ma'am. Yes.
All right, Mr. Webb. Mr. Webb is here for a 30-day motion for release.
Yes, and Your Honor, the state earlier today filed charges of trafficking and possession of cocaine with intent to sell or distribute. The 3 counts of delivery of heroin at and near Park were declined.
All right, Mr. Webb, you were brought before the court for a 30-day motion for release.
Mm-hmm.
The state has formally filed the charges, even though that they have declined to file the delivery charges. They've still filed trafficking and the possession with intent to sell. So there's no action for me to take today. Okay. All right.
So no, I don't get no type of release, no type of bond reduction or something, because really I don't even understand what they're talking about.
All right, so then talk to your attorney and they should explain it to you.
Do I get a piece of paper or something so I could, look at it or something? How do I?
Sir, you were here today for a motion for release. That motion is being denied. I will sign the order. If you want to see a copy of it, you can speak with your attorney. Any other issues, you need to speak with your attorneys, okay?
So can you say my file charges again, what I'm charged with?
Your Honor, the state filed charges of trafficking in heroin between 4 and 14 grams and possession of cocaine with intent to sell or deliver or manufacture.
Okay?
Thank you.
All right. Crystal Prasad?
This is also a motion to release, Judge.
Hold on, Your Honor.
Ms. Prasad. All right, Ms. Prasad is here for a 30-day motion for release.
Yes, ma'am. And the state has not filed an information at this time. Ms. Prasad is entitled to a release on these charges. I would just ask if the court could advise her that the original no contact order for the alleged victim, Larry Miller, is still in effect.
All right, Ms. Prasad, you were brought before the court today for a 30-day motion for release because the state has not yet formally filed the charges that are pending against you. So I will sign that order granting the motion for your release on your own recognizance. It does not mean that they will not file the charges or that they can't. And so you, one, need to pay attention to your mail so that you can see if they file the charges when you have to return to court. And two, there were orders, there were stay away orders that were given to you at the time of first arraignment. Those orders are still in effect. No contact with the alleged victim in this case. Do you understand that?
Yes, ma'am.
Okay, good luck.
Thank you.
Joanne Brown?
She's still, Your Honor,
She's still on
Still
loan.
on loan.
She's still on loan? Okay.
I don't know what, Your Honor, I don't know if you
So
want
how
to.
did she make a second look?
Because what I won't
She
go into a
hasn't-
whole lengthy explanation. I just don't know if you want to keep having her reset time and time again when I think she's also reset on the first appearance. When she's going to come back, I think, when she comes back from the hospital.
Yeah, well, how do I affect that order? That she
That's
doesn't come back until she's
Adam.
back?
Joanne Brown.
Uh-huh.
Yeah.
She's on loan, and we're at the point where like.
Yeah,
first
but
appearance
what
reset,
happened is we've
that's caught up
reset her
with the second
for
look.
several first appearances, but she's out on loan.
Has she
And
had
then
her
she's
first
placed on the
appearance?
second look docket.
On PC, but it had her reset for bond consideration.
No, I think the second look does,
She has
is done
bond.
by the,
Yeah.
There's nothing we could do. There's
by the
nothing more we
jail.
can
No,
do
I know
about it.
you don't. I know you
Judge, what would you like to do here? I mean, I'm this was the one that we just got appointed to yesterday.
don't. Oh, yeah?
Yeah, I think we had asked if Miss Brown is the same
Yeah.
person from yesterday.
No, it is.
And I
Okay.
had asked in order for the court appointing us. I think she's in the hospital. I don't know exactly why that is.
And I guess my thought is, we're not doing anything today, obviously. I have no objection on the record, and Adam, you know how to get in touch with me, that when she comes out, if you want to have her set for a second look in here, because I have no problem with that. It just makes more, to me, it makes more sense than continually rescheduling her.
No, whatever way that we can not have it continually reset when she's not available, she's physically not available to be here.
Was she present for her first appearance hearing?
I know.
Okay.
Yeah.
Then we can delete her, Judge. We've been appointed. We'll have to take a look at her.
Okay.
And if need be, we'll bring her back before the court.
All right, thank you.
Thank you.
John Noland?
He's in.
Counsel, Your Honor.
All right, Mr. Noland is being brought for a second look on his bond status.
Judge,
We ordered for a bark evaluation. I guess that hasn't happened yet, or has it? I shouldn't.
I think that can take some time.
Your Honor, he has asked me to ask the court that he be released on his own recognizance. These are a drug charge, possession of cocaine, possession of cannabis, and drug paraphernalia. He's lived here in South Florida his whole life, all 41 years. I got him, Mr. Nolan. He provided me an address that he lives in Hollywood with a friend and the mom. He is working doing tree service. He makes like $400 a week, but the last couple of weeks he hasn't been working, so he really does not have any money to provide this a bond. I think he says bond is $1,000. So he's asking if the court will release him on his own recognizance.
And I think the reason the court was more inclined to sign bark and sap orders are, one, just lengthy history of drug priors. Last year, a trespass, cocaine on a separate case, sentenced to 270 days. 2017, possession of cocaine, 270 days. 2016, possession of cocaine, 270 days. Another possession of cocaine, 270 days concurrently. 2011, possession of MDMA with intent to sell or distribute, and possession of another controlled substance, 160 days. 2010, possession of cocaine. Multiple drug priors before that. Just looking at his most recent arrest, which was November 29th of last year, that was on a capias. June 20th of last year was on a capias on 3 separate drug offenses that he was county sentenced on ultimately. January of last year, he was picked up on a violation of pretrial warrant. So.
All right, I'm going to deny the ROR motion at this time. I'll leave the, if he gets the bark evaluation, or if someone can, if his attorney can find a program where we'll do custody to custody, I'll be more inclined to do that. But at this time, I'm going to deny the motion for release on his own recognizance. J.A. Hosh. It looks like I also, somebody asked for Mr. Hosh to be in the SAP program. He was before the court, well, he was arrested on March 21st, and now he's back for a second look at his bond status. He's got a $1,000 bond on the grand theft charge, grand theft auto.
Yeah, he, one moment, Judge. Yeah, he was arrested early February on a violation of probation on a felony criminal mischief. He pled out his VOP and completed his jail sentence. Was released February 22nd. Theft, 2017. Disorderly intoxication, 2016. 2006 manslaughter, 10 years state prison. I suspect that might have been.
Well, you know, also that he was released on February 21st, and a month later he's back before the court.
No, I think the totality.
I am going to deny that motion at this time. Brent?
Judge, the one thing I wanted to mention to the court, according to Mr. Hosh, he's never missed court throughout all of these type of appearances over his lifetime. He is homeless, 54 years of age, and has no access to money. Due to him never having a history, according to him, of not missing court, would the court take a chance with an ROR?
No, that's, he's ROR'd on count one, and I know that we talked about this before when he was before the court on March 21st, which is why I don't remember who asked, but I believe someone asked for him to be placed in the SAP program, and we agreed. I am not, I'm going to deny the ROR outright. Again, if there's a program that will accept him, that we can sign from a custody to custody order, then I'll sign that unless before that time he's before his division judge.
Thank you, Judge.
All right.
Sure. Good.
I'm sorry, what was that? Okay. Okay.
Thank you.
All right. Michael Belzer. All right, Mr. Belzer has 3 grand theft charges that there are $1,000 on each count. He's back for a second look at his bond status. He was arrested on March 22nd.
Yes, he came through over the weekend before Judge Colra.
Yes.
I'm showing 22nd.
The last name is a hyphenated Matt one. Okay.
So, Your Honor, there's 3 separate PC affidavits alleging that on February 27th, March 11th, and March 20th, he returned to the same Home Depot and on each occasion committed a grand theft. I don't have any notes about criminal history. I don't know if pretrial has any notes.
Judge, I'm sorry that you're not waiting on me. Are we waiting to hear his priors?
Well, I guess you're gonna have to talk a little bit louder. I was being given all the priors. We just got to 2017. We started at 2014.
He was sentenced to Florida State Prison. He was released from Florida State Prison April 3rd of 2018 on the burglary dwelling charge. And in the last few years, he had at least 2 failures to appear.
Okay.
Judge, in regards to this individual, he does currently live with his brother. He does have a valid address. Unfortunately, he's not working at this time and has no access to money. He's asking the court if the court would be willing to place him on pretrial release. And if not, there is a medical condition we do need to address. As you can see, he is holding his left arm. It seems, it definitely looks infected and swollen and black and blue around it. So if the court was not inclined for pretrial, we would ask for a medical order to have him seen.
Oh, he has not had that since he was been in since March 22nd?
He saw the nurse, but the nurse said that they needed to send the doctor, and the doctor has not seen him as of yet, no.
I want to go to a real hospital. Hospital wouldn't care.
All right, I will sign the order for the medical. Mr. Belser, only because I can't pronounce the other last name, so I'll call you Mr. Belser. Has several going back to 2014. It's all thefts, a lot of thefts. He was released from incarceration last April 2018, and he's had several failures to appear. So I am going to leave the bond in place, and I will sign the order for him to see the doctor.
Thank you, Judge.
All right. Sabrina Rosenbaum.
North Broward, Your Honor.
All right. Ms. Rosenbaum was arrested on March 22nd. And how much is her bond?
$2,000, Judge. 1,000 on count 1, 1,000 on count 2.
All right. What's this? What's the...
Judge, I spoke with Ms. Rosenbaum. She had been doing really well, but unfortunately it looks like she has relapsed here. Prior to her relapse, she had completed a residential drug treatment program. She had gotten herself a tow truck and had been running her own business. She was doing that for about, I think, a year. Sabrina, I don't want to misstate what you told me. But unfortunately, it does look like drugs have kind of creeped back into her life, and so she finds herself in the North Broward Bureau. Judge, she's asked my help in trying to get treatment set up for her. I know that she wants to get clean. She had done it before and is trying to do that again. Judge, she's unable to afford the $1,000 bond, or excuse me, the $2,000 bond. I tried to get a hold of your brother, but there was no answer on that call. Judge, would the court consider having her screened by BARC and ordering custody-to-custody transport on the first bed that is available if she does qualify for their services?
I would like some help, Your Honor. I need it.
All right. Yes, I'll sign that order, but how long? That's the other question I had. a couple of days ago is how long does it take for BARC to screen them? And then,
Place them if there's a bed available. I don't know what the waiting list is there.
I also, Susan B. Anthony would also be another choice of mine because I have to get my daughter back.
I know that she had previously gone through Susan B. Anthony.
I completed
successfully.
Susan B. Anthony, 10-month residential.
okay. And so what I say on these, because I don't want to hold people up, because I know that sometimes there becomes an issue if I sign an order saying, and then it takes a period of time, then we're still sitting here. So I can leave the bond in place and you work on the BARC or whatever, and if that comes through, certainly if it's something that still can be brought before me, I'll sign it, but then it may be best handled in the division.
Is there any way to be
because
ROR?
there's always some kind of snag.
Sure, and I guess, and Mr. Linder, I've been speaking for a minute. I know.
Go ahead.
I can keep going, Judge. I know. I guess let's go in order here.
Because the last time I was trying to help and sign that order, but then the guy comes back, I can't get out, so I don't want to hold.
Yeah,
She's asking initially if the court will release her from custody and allow her to obtain that treatment herself from the outside. Of course, if she is released from custody, ROR, or if she's placed on pretrial, she'd have the opportunity to do that. If the court is not inclined to grant either of those requests, then I think I would ask the court today to order a BARC evaluation for her. I guess we could do that even through pretrial, like the gentleman this morning, and that when the bed becomes available, he could get transported over there. But again, I don't know what the timeline is for that as it pertains to Susan B. Anthony. We haven't reached out to them. I just spoke to her maybe 15 minutes ago. So.
Oh, I understand.
And I don't think we have any perfect solution. It's really just trying to find the best. My concern frankly, about RORing her at this point and leaving her to her own devices is that requires a lot of confidence, and it could be setting herself up, considering the allegations are she was found by a Good Samaritan at an intersection, passed out behind the wheel of her vehicle. I don't necessarily have that level of confidence. So possibly the same thing we did earlier with the combination of BARC with pretrial might be the best out of all the choices, might be the best at this point.
All right.
I did speak to Mr. Goldberg about Ms. Rosenbaum, and I do recognize she's gotten help before. She's had periods where she hasn't been in any trouble.
All right. Thank you, counselors, for recognizing that this is this is not one of the run-of-the-mill types of cases. Ms. Rosenbaum, I hope you realize that your attorney is looking out for your best interest at this time. So I hear you, but guess what? The proof is always in the pudding. It's up to you what's going to happen. So I will release you to pretrial supervision. I am going to, you must undergo that BARC evaluation and whatever follow-up that they've indicated. And I didn't want to, because if she's going to do the BARC evaluation, to say random testing.
Well, the only thing I was thinking is because we don't know when that evaluation is going to be.
Random testing until?
Exactly.
All right.
Please.
So you'll be doing random testing until there's a determination as to whether you're going into BARC or not.
I would prefer that, actually.
I'm sorry?
I would prefer that, actually.
Let's do weekly testing.
Okay. 3 times a week, please.
All right, we'll do the weekly testing. All right? All right, good luck, ma'am.
Thank you.
All right.
Good luck.
Thank you.
Hugh Jacobs?
He's in the main jail.
Yeah.
Skip Mr. Rozier.
Did we skip someone?
Yeah. On the bottom of page, of course my page numbers are cut off.
Oh, you know what? I just...
The defendant underneath.
Victor Rozier. I'm sorry. I skipped Mr. Rozier. It's because I started writing in his space.
Hold on, Your Honor.
All right. Mr. Rozier. All right, Mr. Rozier is back for a second look at his bond status. He was arrested on March 22nd, and he has a total of $2,025 in bonds.
Mr. Rozier, at the time of this arrest, is out on possession of firearm by convicted felon. He was out on a $5,000 bond on that case.
All right. All right, so the allegations are I don't know how. All right, the allegations are concerning here. I am going to deny the release for pre-trial. Mr. Rozier, the allegations that he was found sleeping in someone's bedroom and then with drugs. So I'm gonna leave the bond in place. Good luck, sir. And then let's.
Judge, would you consider signing an order allowing him to participate in the SAT program while he's in custody?
Yes, I'll do that.
Thank you.
All right, Hugh Jacobs. All right, so Mr. Jacobs was arrested on March 22nd. Judge Cora issued a bond of $1,000.
Let
me look at this.
I suspect Judge Colra kept his bond in place based on his history. 2008, robbery with a weapon, aggravated battery, great bodily harm, felony battery on a victim over the age of 65. He was sentenced to 10 years in Florida State Prison. Yeah, we're looking into when he was released. And also in 2007, 2 separate possession of cocaine cases. He violated probation on each case and was sentenced to 5 years in state prison.
Judge, at this time, the defense is going to request on count 1 an ROR. He's 37 years old. Unfortunately, at this time, he's not working. He's having a lot of health issues. He's got permanent nerve damage. He's having seizures. He also has a condition that I can't openly say at this time that is extremely serious. According to Mr. Jacobs, he has no prior failures to appear. He's been in custody since Friday now, and what he's asking for is a release on his own recognizance so he can take care of his medical issues at this time. I understand there's a little bit of history. That was about more than a decade ago. So we are asking the court to take a chance. If not, he does live currently with a friend. He has been in Broward 10 years, but he's been living with a friend for several months. It is a valid address, so if the court was not inclined, we then would ask for pretrial release.
And Your Honor, I understand that Mr. Jacobs is advising his attorney and wants the court to be aware that he has medical issues that he wants to take care of. But as far as actions here, he was found passed out on the boardwalk in Wilton Manors at middle of the day. Looks like he was under the influence of drugs. So his actions really don't indicate someone whose main interest is getting the medical help or taking care of their medical issues.
Judge, Mr. Jacobs indicated to prove to you, the court, that he's trying to combat his addictions, he would be open to ordering as part of his release to attend NA meetings daily. If I could just have one moment. The last thing he wanted me to advise the court was he was in the process and still will be once released. He's close to getting a job at Whole Foods because he is trying to work. And due to the pain that he's suffering, unfortunately, he's not doing it the proper way, but that's the reason why he was self-medicating for the pain.
Does Mr. Jacobs know the address that he has an address? You said something about staying with a friend.
Yes, I could have him state the address on the record, please.
2520 North Andrews Avenue, ma'am. Wolf Manors.
Wow, listening, but I know.
Well, Mr. Jacobs was in custody for how long before now?
He was arrested Friday.
No, I mean, I think that there was some...
He was released in November of last year after being sentenced to 10 years state prison in 2009 on a top count first-degree felony.
I would have hoped that during that period of time that there would be no drugs.
No, but unfortunately, we all know, according to the medical industry, that relapse is a part of recovery. Unfortunately, he's just not had the money or the means to seek that help. That's why we're hoping if the court took a chance that by ordering him to do NA daily, it would hold something over his head to make sure he tries to, again, combat the addictions he's been suffering from.
Well, NA is going to be voluntary, and I don't have confidence that that's something that someone is going to do. I was asking about his address because, like the gentleman or the woman before, he would have to. I'd put him on a GPS monitor and he would have to do a bark evaluation. And then random testing every week.
Judge, he's okay with that. He would just a little minor request. He's got some problems with his right ankle. He just asked that the monitor be placed on his left ankle.
Is there a preference for the ankle?
I had surgery on my right.
She just asked.
Okay.
Thank you.
Okay.
Okay. There you go.
So what was the level 2 with GPS, random testing weekly? All right, sir. Good luck.
Sure.
All right. I believe that we're at the end of our docket.
Yeah, we have some. Well,
one more. Who's
have?
that? Oh, what happened to Dalvon President? That's the
Judge, the main jail was able to locate him and bring him down. He's here right now.
All right, Mr. President, we needed your presence because yesterday you were before the court. There were 2 drug charges that I did not find probable cause on. The state did ask for 24 hours to perfect. They've provided me now with the affidavit. The issue was with the testing, that they had not tested to see if the products were what they say that they were. So they have now produced the supplemental affidavit, and it does, they do confirm that the tests were performed and that there was a presence of marijuana and MDMA. So at this time, I am going to find probable cause for those 2 counts that I did not find probable cause for yesterday. And then the bonds on each of those will be $1,000. Okay? All right, good luck, sir. All right, what other, I don't have any other.
Grant Trapello on the felony docket, page 4.
We didn't address him? All right, so Mr. Trapello. Mr. Trapello has a total of, is it 5,000, 5,000, and 1,000?
It is.
Is that what he has?
Yes, and I believe one of the things the court took into consideration setting those bonds, Mr. Trapello has pending charges of resisting with violence, unlawful use of false name ID, and a second case of aggravated assault with a firearm.
Those cases are still pending?
Yes, ma'am.
And he's out, he's out on bond on, he was out on bond on those cases?
I'll check. Frankly, they're not new cases.
Okay.
Okay, yes. I'm looking at the aggravated assault with a firearm. It's a 2013 case. It went through Judge Porst's division for quite a period of time. It appears that I suspect competency was restored. So he then went to Judge Lynch's division. He's now in front of Judge Casey. I can tell you as recently as September of last year, his community release was revoked based on a new domestic violence battery arrest. He's been on pretrial and failed to comply with pretrial.
Judge, Mr. Trapello wanted me to inform the court that the DV case, according to him, was dropped. As you heard testimony from the state attorney with him being in front of Judge Porth, I have had the opportunity to discuss things with Mr. Trapello. He does suffer from severe mental illness, multiple diagnoses. Unfortunately, he's not working, but does receive $750 a month in SSI disability benefits. If the court was inclined to post a $1,000 bond on each count 1, count 2, and count 3, he has indicated to me he does have that money in his belongings. If the court was to sign an order to allow him access to his money inside his personal property, he then would be able to post the financial bond.
And, Your Honor, frankly, I think the bonds that the court set were reasonable and appropriate, considering, while dated, he was already out on 2 separate cases involving felony levels of violence, and now it's the 3rd case of felony level violence.
And he also indicated that those 2 cases, according to him, one is from 2013, one is from 2015. And he indicated he has no history of failures to appear, according to him.
Okay, let's see.
Where does Mr. Trapello, does he have an address?
Yes, ma'am.
Can you take the address for the record?
6881 Southwest 3rd Street, Pembroke Pines, Florida, ma'am.
Who lives there?
Me.
Who else?
And a roommate. And my girlfriend.
Let's see.
All right. I'm going to place Mr. Trapello on standard pretrial supervision, along with the $1,000 on each count for the bond.
Your Honor,
You're gonna get out.
just want to check one thing here.
Okay. So $1,000 on each count, plus pretrial supervision.
And considering the fact that he has violated pretrial on numerous occasions, I would ask the court to consider a GPS in this instance.
I'll grant that. Yes.
Those are asked. Judge, Mr. Truppello is indicating he's disputing any violations of pretrial release.
All right.
Your Honor, I can tell you right now, case number 15-2044 CF10A, the Honorable Judge Ari Porth, on April 28th of 2016, signed a warrant ordering Brand Truppello to be held no bond for violating pretrial. That was on a GPS level 1, when he was leaving his residence without permission, at times without permission from pretrial release services, and his activities were unknown.
All right. Mr. Truppello has gotten his time before the court. He's got to post the monetary bond plus be on the level 2 GPS.
Your Honor, this last gentleman coming up is...
Do you have more?
Yeah, he was on the docket, Your Honor.
Who is this?
This is Aaron Stegman. You had released him to pretrial with the GPS last week. I guess pretrial's not been able to verify an address at this point.
Judge, can I just intervene and ask the state attorney if they're willing to make an offer on the misdemeanor case?
What is the charge? Because I have no paperwork on him.
It's really a moot issue at this point because he has a felony and a misdemeanor. Let me check.
Oh, I'm sorry. I thought it was just a petty theft. Sorry.
Oh, yeah, no. He has a case number on 19340 MM20A, and then there's Devin. He has a felony case too, right?
What's the name of this defendant?
Stegman. Then there's a retail theft over $300 coordinating with others, and another count of petty theft. That would be a felony case. And Your Honor released him to pretrial GPS on those 2 counts.
Okay. And so they
Judge,
have, yeah?
Go ahead. No, I'm sorry.
And so they have not been able to verify his address. Is that correct?
Excuse me, Dad.
Yeah, unfortunately, he does live with his father, and his father had a heart attack and is not currently in the home right now to verify those, whether he lives there or not. Is that something pretrial could do, call the hospital, or is that outside of their job description?
The court's additionally...
Judge Pohl? That's Mr. Stegman? All right. Mr. Stegman is scheduled for his division judge tomorrow, so he can handle whatever issues
Well, that
there.
would be on the misdemeanor, but also just to let the court, advise the court, when he came through, Your Honor, it was showing an Indiana address. I think that caused the court some concern about just, at first you would release him on the misdemeanor capias to pretrial, but then when he came back add charge on another felony theft-related matter, I think it gave the court some pause.
All right. Well, I'm not going to make any changes.
I believe
believe that's the last case.
Is that the last one? Mr.
Judge.
Linder, you did not ask for anybody else to be brought before the court this afternoon?
I definitely did not.
I have one last one, just a photo order. I'm sorry. I'm not asking anyone to be brought. I got a request for James Dixon, case number 193685 CF10A, Judge, just so we can take pictures of it.
I'll sign the phone order.
Thank you, Your Honor.
Have a great day, everyone. Thank you.
All
Thank
right,
you, Judge.
take care, Mr. Hill.
Thank you.